Hi there, I'm Sarah McCoubrey from the Ontario Justice Education Network, or OJEN, and this is a short video about some of the common mistakes that we here at OJEN see or hear about that teachers make when they're teaching law in the high school classroom, with some ideas about how to avoid those mistakes. The law is confusing for lots of people, and they obviously go to the sources that they've seen. And one of the most common mistakes is to confuse American law with Canadian law. When people make that confusion, they will often plead the fifth when they're arrested. They will expect Miranda rights. They'll wonder why a warrant isn't shown to them before someone enters their house. They might expect to go to trial and argue about child support. All of those are aspects of American law. The confusion makes a lot of sense given how much American TV we have access to, but a common mistake is to not learn about or distinguish between Canadian and American law. We do have similar kinds of protections in Canada, but they come from different parts of our legislative framework, and you exercise them in a different way. One of the most most important differences between Canadian and American law is in the way our rights documents are structured. The Canadian Charter of Rights and Freedoms is a balancing of rights and freedoms. And anytime there's an infringement of a right or a freedom, the government has to show that that infringement is demonstrably justified in a free and democratic society. That creates a mechanism for the times at which two rights come in conflict, and the government has to make a choice or come up with a strategy that will allow both of those rights to be respected. Or a decision made about which right it will be protected in that case. In contrast, the American Constitution has a list of rights, and those rights are not balanced against each other. And in fact, some of those rights are held as having a hierarchy or being more important than other rights. That's quite a difference in the approach that comes at law and that courts can take, and it's actually one of the things about the Canadian justice system that many other people in other countries are envious of, that we have a mechanism built right in that encourages or facilitates the balancing of conflicting rights. That makes it easier for us to respect difference, to have an evolution of our legal system, and to promote a respectful, pluralist society. A second very common mistake that people make when teaching law is around the term civil law. Civil law has two meanings. One meaning is to describe a civil code system, or the system used in countries that have a civil code, like France, and by extension, or based on our history, Quebec has adopted a civil code system as well. That means there's actually a code in which the law is written down, and when it's time to apply the law, there's a document to go to that simply states what the law is on that matter. In contrast, the common law, which is what we have here in Ontario and the rest of Canada and in most of the Commonwealth countries, is a system where our law comes from both legislation and from precedent, from the evolution of legal meaning or the interpretation of legislation over time by judges. And as they do that, more senior level of judges or appellate level of courts consider different questions, and their decisions become binding on lower level of courts. That is where we have the development of our common law, and that allows for the evolution over time of our legal understanding, as well as a way for legal questions and legal issues to change over time. The other meaning of civil law is to describe all of the matters of private law. So within the common law system, there is public law and civil law, or private law. Frequently I hear teachers describe this as law that's decided privately, public law being law decided by judges. Those are inaccuracies. Public law describes all the areas of law in which it is a dispute or a matter between an individual and the state, an individual and the government. So criminal law, different kinds of administrative law, immigration issues are all public law. Private law are disputes, or civil law, are disputes between two individuals. The government is not involved in that process. They're not involved in the remedy. And so we have both individual disputes between perhaps myself and my neighbor, myself and my employer, or disputes between an individual and a company, or between two companies who are considered private entities. Contract disputes, defamation, family law, divorce matters, those are all areas of civil law or private law. There's a little bit of confusion in that there are some of those areas in which governments have started to regulate some minimum standards. For example, in the employment setting, which is a private dispute between myself and my employer, the government has established minimum employment standards and minimum occupational health and safety standards. And if the dispute revolves around one of those issues, I, as an employee, might have access to a cheaper or an easier process than the courts to try to maintain compliance. And there's often confusion about those areas that are conceptually private law, but in fact operate in a public or an administrative tribunal setting with additional procedural protections. So increasingly that distinction between private and public law is no longer that useful for lawyers in organizing or in distinguishing the kind of law that they practice. But I notice that law teachers often really find that to be an important distinction. In fact, what's more important is to understand who the parties are and what kinds of remedies are available. Which brings me to another really common mistake. Because in most law classes, most high school law classes, I would estimate that between 80 and 90% of the focus is on the criminal law and the charter, despite the criminal law only making up maybe 30 or 35% of the curriculum. We know why that is. It's more interesting to students and teachers. It's easier to engage people on. They've seen things on TV. The result of that, though, is it gives people the impression that criminal law is the biggest area of law and takes up the most attention in our courts, and is the area of law most people are likely to be affected by. And that's just not true. In fact, of the legal disputes in society, very, very few actually go to trial. I think this stat is about 3% go to trial. That means most of those are being resolved by mediation, through discussion with lawyers, or through individual resolution of that dispute. Tribunals, other kinds of self-help environments are helping people resolve their disputes long before it goes to trial. If something does in fact go to trial, most trials are about civil or private matters. The criminal setting is a very small slice of the legal world, and yet it's a very big slice of what happens in most classroom environments. This gives people the impression that that's the area of law they need to be prepared for. It gives them students the impression that most people will encounter a criminal law issue, will be a victim, or involved in a criminal law issue, which is just not true. And in fact, what most people will have are family law disputes, problems in their workplace, difficulty setting up a small business, landlord-tenant disputes. They'll buy a house, they'll sell a house. Those are the areas of law that actually affect most people's lives. One of the misconceptions that comes from this overemphasis on the criminal law is around the remedy that's available. If the only area of law that you study in high school is criminal law, you start to think that what the courts are about is punishment for some sort of injustice. That often leads to young people, once they are an employee, say, who has been treated unfairly, expecting punishment as the remedy that their employer will have to experience, when in fact, in a civil law context, jail is not available. The remedies that are available for disputes between individuals are generally about awards of money, and the idea is that the award of money will put the person in the place they would have been in if the contract dispute or the mistreatment or the injustice hadn't happened. Money is the primary remedy available in civil law disputes. Occasionally there may also be an order, for example in a human rights context, of mandatory education, or an employer having to do education of the rest of their employees in order to stop a certain kind of behavior. But there is not a remedy available in our private law system that is like jail. And when students only learn about the criminal law, they develop an idea that injustice is most often remedied by punishment and jail, and then are both frustrated or disappointed to find out that those principles are not available in most of the contexts in which people have real disputes in their lives. And in fact, punishment is also not a part of our sentencing philosophy in Canada. It's not one of the principles of sentencing. So this idea of punishment or of revenge for a legal dispute often comes from the overemphasis of the criminal justice system, but is not accurate. And then finally that leads to a related inaccuracy, and that is that the victim and the accused are equal parties in a criminal dispute. In fact, in a criminal case, the parties are the state, Regina, or R.V. McCoubry, the accused. So the dispute is always between the state and the accused. The victim is simply a witness who provides evidence about the alleged behavior of the accused. And victims do not have the right to withdraw charges, to decide whether or not to proceed. That is the obligation of the Crown to consider those things, and the Crown decides if there's a reasonable prospect of conviction. Often people talk about victims' rights, and in fact, victims have very few rights in the formal procedures within a criminal trial. There is a right to provide a victim impact statement in the sentencing process, but the victim in an alleged crime does not control the proceeding and does not have the kinds of rights that an accused has. Our system protects the accused rights. It considers the interests of the victim, but the victim does not have rights equivalent to the accused as if it's a dispute between the two of them. In a private law situation, it is a dispute between two individuals, and they have similar and equivalent kinds of rights. This is again one of those small errors that over time leads people to believe that our system is unfair because they have developed unrealistic or inaccurate expectations of the kinds of protections that are available or the kinds of emphasis that our legal system has, expecting more of a revenge, more of a punishment kind of culture than our legal system has. Finally, the overemphasis on criminal law also gives people the impression that they might have to deal with criminal law problems in their life, and in fact, it's very unlikely. My final common mistake that teachers make is to confuse the story for the importance of the case. In the story of the case, you'll often hear interesting facts, and it's easy to think that that's why the case is important. But in fact, it may be the legal reasoning that's most important. A great example is the recent Insight decision, a case about a safe injection site in Vancouver, and the dispute was around whether or not the government had followed an appropriate and fair procedure in initially granting an exemption from the Controlled Drug and Substances Act, and then later refusing to grant that same exemption. It's easy to look at that case and think it's about safe injection sites. That's this part of the story that's interesting to students, and you'll use as a hook, and it'll get students engaged in the issue. But in fact, the significance of the case comes much more around when governments are allowed to act in a certain way, and the basis on which they can choose to grant or withdraw this kind of exemption was premised on something called the harm principle. The case looks at that harm principle, it looks at the significance of that in assessing government actions that may also adversely affect a group of society, and sets out a test or an analysis that will be used in the future. So the next case that relies on the Insight decision may not be about safe injection sites. It might be about, in fact it probably will be, about the current appeal that's out regarding prostitution in Ontario. It might be about other kinds of government action that people feel creates more harm than protects. Other issues where an individual's interests compared to society's morality questions come in conflict. So that's a good example of where the story, the facts, are simply the introduction into an area of legal reasoning. And it's important to pay attention in the decision itself, in the head note, to what the judge is telling you is the important aspect of the decision. And that's where you'll find that you're on the right track and you're applying that case in an appropriate way. So those are a few of the common mistakes that are really easy to avoid and that do wonders to set your students out on an accurate understanding of the Canadian legal system.